provided to Mr. Carter, who testified previously. He is not here tonight. He was supposed to send us a letter indicating that there was no change in his opinion as a result of that. However, we would offer that those additional tax returns for you to certainly look at and consider in any decision you make this evening. So I'll ask our court reporter to mark those, and these are the ones that we provided.
Your Honor, I'm Bruce Monty here on behalf of Waldo Incorporated. We're going to tell you here in a little bit about records from this proceeding that appeared on the internet. And I mentioned last week the importance of this information remaining confidential. I have no reason to believe now that any information we previously provided has been disclosed. I think Mr. Carter undertook that he would not disclose any of this, but now that we've seen, and I'll show it to you here later, a reference to a document that is exhibited in this trial, which is our list of employees, that's on the internet and attributed to the city of Kaufman. We want to be absolutely sure that we can rely on everyone in this room to know this information will become public.
We have no problem with that. Members of the board. So we will tender these to the board's permission. We've marked them 1 through 6, which are 6 documents which were provided to us through representatives of the operator and or owner in this matter. And with that, we have no additional evidence that we are aware of unless the property owner and operator of the facility we refer to as Dallas Crown has any additional information. We're unaware of any we subpoenaed. We do not have a lease. I think that was an issue last time about the lease of the premises. None has been provided to us, so I will assume that there is no written lease between Waldo and Dallas Crown. So with that, if they have any evidence or wish to address the board on any matters before any concluding remarks, or if I can answer any questions.
Do you all have any agreement about how we're going to handle the records that have been produced to us tonight?
I think you can obviously review all those and discuss amongst yourselves when you're ready to make a decision. I don't know what the plans of the owner-operator are, because I don't know what your decision is going to be. To the extent that there's any subsequent action, legal action, which an applicant may take, or which property owner may take as a result of an amortization order of the Board of Adjustment, those records would then be transmitted to court.
We want those in the custody of a specified individual tonight, though, for review by us, no copying?
Once you have them, you review them, you've made a decision, at that turn, they'll be turned over to the secretary to keep the record of your proceedings and whatever decision you make, because they then would have to produce those to court.
Mr. Monty, who you want?
Well, I just want to be sure they were kept under seal so that nobody can make an open records request when we get our tax records.
Yeah.
Same with the other information that we started at.
The only information that has not been released in a public records request is the big, thick, couple of thousand pages of the financial records. There was a summary that Mr. Carter had written that went along with that, and we of those documents, and that's the only part that's available for public review because of the financial security of those, and the city secretary has custody of those in the vault, and no other person. They're in the vault.
Get them because they need them.
Yeah, that's we can get those.
We still have to have, or should have.
But these tonight, when we leave them with the court reporter, and then as we need them, we'll get them from her, but let her be the custodian?
For this evening, certainly, and then it sounds like you've made what sounds like satisfactory precautions to protect
And then when you're,
confidentiality of the others.
and when you're through this evening, we'll return them to the vault.
Okay. And we agree that they're to be kept in confidence and not subject to open record request. The ones made to seek them will be told so we can fight it.
Yeah.
Yes, we'll do that.
Thank you.
On the review of these now, Is it something that we review individually or as a board at one sitting, or?
Well, there's been some issues with regard to, my understanding with regard to your right to meet in closed session. There's been some issues that have been brought up by the property owner, which is their right to do, concerning any executive session you have with me, feeling that it would be unfair for you to have access to me and me, quote, presenting the case. So any deliberations you will have in this manner in order to avoid any appearance of impropriety, we would ask that you do it in public. While you're up here tonight, anyone's free to stay here or not stay here. It would be my intent at the appropriate time to present to you a proposed order based on what I think the evidence in the record would demonstrate. I assume that you've got before you all the exhibits and the transcription of all the testimony that's been taken in the previous 5 nights of hearings that we have had. If not, I have copies, which I am more than happy to allow you to have tonight, so that more, you know, one of you could be looking at something, one of you could be looking at something else. So that's entirely up to you how you wish to deliberate on this. And like I said, I don't know that there needs to be, nor do I intend to make any grand presentation in terms of the closing argument. You've heard this now on 5 different occasions. This will be the 6th time we've gathered about this issue. You've heard from citizens, you've heard from people that work for the property owner and operator. You've heard from attorneys representing some of our citizens on this issue. So assuming that there's no other evidence to be presented, whenever you are ready, we'll present you with a proposed order. So, and I don't know if Mr. Long and Mr. Kluger have any additional testimony that they'd like to offer.
And we can do that still on the pretext of being in the open
Sorry about that. My daughter put that on there.
That's cute.
That's about all fine.
What are you saying, John?
That we so choose to review this while still on the open forum.
That you mean during the
No,
public
we're-
hearing?
Yeah, with open hearing.
Excuse me, let me go outside and take care of Mr. Dodd.
Wait till we get back.
That's always my partner. Okay, sorry.
Chairman Elsner, ladies and gentlemen, again, I'm Bruce Monty here on behalf of Waldo Incorporated. I want to begin by saying that I have very high regard, as I said last week, for Mr. Holm. I've got very high regard for the lawyers you've represented, that you've retained. They are among the best on matters like this in the state of Texas and are very competent. By what I'm saying today, I do not mean to make any personal aspersions, but we are here, make it clear, on a death penalty case for our client. Once the order is entered, or once you tell us that we can no longer do the work we're doing at that location, our business is over. Therefore, I hope you will understand that we take this matter rather seriously. We urge you to do that. I will begin by reporting to you what you may already know. Earlier this morning, I filed a suit against the city of Kaufman and this board. I did that after careful thought and on grounds that I believe are substantial. I'll never go through them in a moment. I will tell you that after we filed the suit, we have presented to 2 different judges in this town applications for restraining order to stop this meeting from going forward. Neither judge granted that order. Those judges felt that this process, those judges had faith, I believe, in you to do your job in a responsible manner. I have no choice but to implore you to do so. But let me first tell you why the concerns we have, and we would ask you to look inside your hearts and determine for yourselves whether any of these concerns are well-founded, and to consider them first before you begin making judgments about us that are in our business's future. Our first concern is that some of you may be biased or prejudiced against our client, and one of you, because of life's twists and turns, inevitably has to. I've known Mr. Holm for 25 years. I knew his wife longer than that. I do not, again, but I do not mean to be anything other than completely respectful of him and his memory of his wife, which I'm sure is fond and painful. But the fact remains that I am unaware of a single individual that is a greater adversary to our client than was Mary Nash. Mr. Holmes' photograph, well, let me give you some. This is a copy of the suit we filed earlier today, with the exception of 2 exhibits, or with the exception of 5 of the exhibits. The first 4 exhibits that are missing are nothing more than the record from the prior hearings that you all have had. The 5th exhibit that is missing is a letter that I had written Mr. Hager and his associate Mr. Dodd earlier, suggesting that they are disqualified from serving as your lawyers in this matter. And Exhibit 6, which is attached to what I've just handed you, is a printout from the internet of the page that says www.marynash.org. If you will see the second paragraph of that printout, it says, quotes, "Her horse meat website became the Bible for everyone involved in fighting horse slaughter. Hours of dedicated work should not be lost. She has asked us to continue her dedicated website, and in honor of Mary, we will." And on the next page, you see a picture of a very handsome couple, one of whom sits on this board. With all respect to my friend, Mr. Holm, this is not a case he needs to sit in decision on. And I respectfully ask him to search his heart and his soul and determine whether in fact he has a bias or a prejudice in this matter, and we ask him to recuse himself. And unfortunately, we ask that you reconsider any vote that you took that was reliant upon his vote for the decision. We have other concerns that you may be biased. Since our last, you all determined on November 29th of last year that what we were operating out there was a nuisance. Then, about 2 weeks ago, Mr. Elsner signed a subpoena that I'm handing you. Perhaps I'll keep it. The copy of the supplemental petition that I handed you first, I'm going to call Respondents Exhibit 1. And the subpoena ducis tecum that I've just handed you, I'm going to mark RX2 and hand copies to the corporate court. Now, Mr. Elsner signed this document, I assume, as did Mr. Capehart, approximately 3 months after you all had reached the conclusion that what we were operating was a nuisance. And in this subpoena, you sought information that it seems to me had no relevance to any purpose other than a determination of whether we were a nuisance. And I have to question you. I'm not trying to be combative, but I am trying to be assertive. And I'm trying to ask you to consider in your heart, when you sought this additional information, was there any legitimate reason for you to seek this information other than to serve some purpose that might be embarrassing to my client or have something to do something other than the amortization of the value? I don't see it. We asked the court earlier for the privilege of questioning each of you or questioning other people that may shed some light on whether or not you too should serve as the person making the decision in this case. Under the law, I can tell you, the law, if you were going to be a juror in a case across the street, the law is fairly commonsensical. If you're biased or if you're prejudiced, you can't be a juror. A bias is nothing more than an inclination one way or the other. A prejudice is nothing more than a predisposition one way or the other. The law makes it clear that if you have a close personal relationship with a party to a lawsuit, or if you are a relative of a party to a lawsuit, you would be disqualified. We're not, the city of Kaufman, well, this is, again, I have no choice today but to ask you to search inside yourself and determine for yourself whether you truly would be suitable to make these decisions about us. Now, the next reason that I said that this is not a proper, that I asked the court to stop what you're doing, is that you all are not elected officials. You all are appointed by elected officials. But the city council told you to determine whether or not what we are operating is a nuisance. But no one's ever told you what nuisance means in the eyes of the law. I'm sure many of the people that have testified in front of you truly believe in their hearts and minds that we are a nuisance. But in truth and fact, that's not many people. And most of the people that are citizens that have talked are representatives of a family that has a direct property interest in our business being closed. So they're entitled to their opinions of what is a nuisance. But the law has to determine for you, and you need direction. You're entitled to direction to know what is a nuisance before you brand us with that label. We also believe, and I believe you can understand this, these are legal concepts, but they're also fairness concepts. You all are charged with, I believe, an untenable responsibility. And let me show you why. I'll hand you what's been marked as Exhibit RX3. This is an outline I prepared of Kaufman Zoning Ordinance Section 9.9. Now that's the section that I'll tell you that you're operating under here today. Perhaps the words of this will be familiar to you. But you will see on the left-hand side, it says that you will, after a public hearing and investigation into these various matters. And then on the right-hand side, it says what you will consider doing. So what you are being set up as both the investigative body, and I'll call that the police, and the adjudicative body, and I'll call that the judge. You didn't ask for it to be written that way. That's the way the ordinance was written for you. We contend strongly that that violates our rights of fundamental fair process that's guaranteed by every constitution that we are beholden to as we stand here in Kaufman, Texas. Now, I don't pretend to think that based on this today, that you can make decisions about whether or not this violates certain provisions of some constitution. I can only point out to you the fundamental unfairness of you having the responsibility of being the police and the judge. And I've asked you, I'm going to get to this point a little bit later, tie it together a little bit later, with all respect to your superb counsel, they should not be the person to whom you go for this advice, because they are tainted in the same manner you are. So we feel that you were handed an untenable job because you were asked to be the judge, the police and the judge. And the last ground on which we asked the judges to stop this proceeding was, as I said earlier, we asked Mr. Hager and Mr. Dodd to withdraw from representing you as long as they were representing the city attorney, as long as they were the city attorneys. We sent Mr. Hager and Dodd, and I'm sorry I had only one copy of this. We sent Mr. Hager, and I'm going to give it to Mr. Holm, because I know he's seen this kind of thing before. Here's the problem that you have. I have told you, and I hope that my manner indicates that I am dead serious about it. I've told you that I think this statute that you're operating under violates our constitutional rights of due process because you combine the police and the judge function. Should you believe me? I know you think I'm being sincere. How would you answer that question? You have no choice but to go with your gut instincts or to ask a lawyer. Well, what lawyer are you going to ask? The same one that is sitting here representing the city. That's the problem you've got. Now, Mr. Holm will see, attached to we filed these papers with the court also, the Supreme Courts of 2 different states, Pennsylvania and New Jersey, have already held that the same lawyer, in the case of Pennsylvania, it was the same lawyer, cannot represent both the city and its zoning board. And it was a zoning board case. The Supreme Court of New Jersey said that the same law firm cannot represent both. The reason is that lawyers, you all know you've got attorney-client privileges. You have the right to adjourn this meeting as you did last month, to talk with your lawyer, because those are confidential communications. The law conclusively presumes that anything that you talk with Mr. Hager about or with Mr. Dodd about, that he will share with the other lawyers in his firm. I'm asking you to take my word for it, but I'm ready to defend it before anyone. That puts Mr. Hager in the position, if he had heard some confidential information or some questions that you had last month at the meeting, and questions about, is this a constitutional statute? Questions that I'll get into in a minute about how do we go about calculating what it is that's to happen to the Crown. If you have questions or concerns, or if some of you are leaning this way and some that way, and if that's shared with Mr. Hager, or if you go to Mr. Hager about that, the law presumes he's going to go straight to Mr. Dodd. And similarly, if the city wants our plant closed, that Mr. Dodd will talk to Mr. Hager about that. We have no way of learning about it because they're both covered by the attorney-client privilege. That is why the Supreme Court of Pennsylvania said it violated the landowner's rights of due process for the same lawyer to represent both. Now, we wrote that letter to Messrs. Dodd and Hager, I've forgotten the day, the 28th of February, I think. I had earlier advised Mr. Dodd about the question. I've not heard any response from them. I've met with Mr. Dodd earlier today in front of the 2 judges. I've not heard them, I think their presence here today suggests that they disagree with me. But I've not heard any reason or any explanation of their reasoning why they disagree with the analysis that I've put forward. And I presented the same points I've made here today, I made in the letter to them 2 weeks ago. So Mr. Hager alluded to that a moment ago. He put you in the box. they want to pretend that if they don't talk with you in closed session, that solves everything. Well, it doesn't solve everything. You still have, if you have warm blood flowing in your body and responsibility flowing through your brain, when you deal with these matters, you know you're going to have to get legal advice from somebody. Well, who do you go to? Do you go to the lawyer that is the adversary, as earnest as he or she may appear? Or do you go to the lawyer that was hired, that you previously relied upon all these previous meetings? We have no opportunity. Of course, you would have to first at least talk to your own lawyer about it. And we believe that they have an inappropriate, permissive leg up with us in as our adversaries in trying to persuade you that our interpretation of these legal principles is right. Let me give you another example. In the Exhibit 3 that I gave you that had the yellow marks on the right-hand side, you will see that there are some lines, there are some items listed in boldface: demolition expenses and relocation expenses. Texas law and your ordinance expressly require you to consider those components in determining what costs my client is entitled to recoup before its non-conforming use can be terminated. Perhaps Mr. Hager overlooked those, but in his previous presentations to you, he made no mention of those. And ladies and gentlemen, those in this case are considerable expenses. And what do we, it puts us in the same problem. If we say we're entitled to have our relocation expenses included, and they dispute with that, how do you resolve that question? That's a lawyer question. Yet here we are again, having to argue against the advisor that you're entitled to have for your private resort. You are entitled to have a lawyer to go in your private sessions with you and do whatever is appropriate in an executive session. There's no law that says that well, the law says you can do that. It doesn't say that everything, all ills are cured if the lawyer doesn't do it. And we are here hoping you will do your best to do a good job, not to do a handicapped job, because there are sound and serious legal issues that you can't get answers to otherwise. Now, we are here, and if necessary, we can put on for you the cost that we will incur if we are closed down. We hope and urge you as strongly as we possibly can to reflect on for yourselves whether you truly should be parties or whether you truly should sit in this matter. I have no choice but to accept for the present whatever decision you make. I simply ask you to, and if you need to take a break, fine, however you want to deal with it. If you want to deal with it summarily and tell me to sit down and get on with the rest of our case, I'm happy to do that. But I simply ask you to not go any further with this matter without determining for yourself, in your soul, in the same seriousness that you would approach your maker, that you can be fair and unbiased to our claim. And I'll stand by and see if there are any questions, and otherwise we'll go on with putting on evidence. Or if you all would like to deliberate, I'd appreciate you considering my points. And I'd appreciate Mr. Holmes' recusing.
May I respond? May I respond?
Yes, sir. Go ahead.
Thank you. Mr. Monning is giving you Exhibit 1, which says City of Kaufman, Texas. I would suggest to you that you are not the City of Kaufman, Texas. You are the Zoning Board of Adjustment.